Thank you all for joining. What I'm going to do is talk about rental assistance and where that's at this point in time, diversion program, the latest diversion program, and what you need to do to comply with that. What you need to do to file a landlord and tenant complaint, what you need to do to file a writ of possession or an alias writ of possession. And then at the end, we'll take some questions and hopefully answer as many as I can. Starting first with rental assistance. I assume you all know by now that the rental assistance applications have ended as of last Friday. They sent out an email to everybody. So you should know about that. If you don't, that's the situation that we're dealing with now. As of last Friday, you can no longer apply for rental assistance. Okay, here's some real quick statistics on rental assistance. There was $214 million that was available for phase 4 rental assistance. Of that, this is as of last Friday. Of that 214 million, approximately 16 million went to administrative expenses. That left $198 million to be distributed. 184 million was distributed. And obviously you don't need to know these numbers, but you'll see where I'm going with them. That left about 14 million to still distribute. The city tried to get an additional $450 million. It was a pipe dream. They were hoping and redistributed funds. They really would have liked to see the state and the federal government give them around 250 million. What ended up happening is the federal government gave them approximately 8 million, and they got about another 7 million from the state in reapportioned funds. And I'm not going to get into how that all happens, but suffice it to say, they got another $15 million. That gives them about $29 million left to distribute. If you do the math, and I don't know if Greg's on the phone here, but he's real good at this. He's been working through this for months and telling the city about how the math doesn't add up. Because when you do the math, you realize that the $184 million that was already given out was paid out to 23,262 applicants. The city got 81,905 applicants. So gotta love Siri. Okay, so when you do the math, you realize that there's less than a third of the people that applied are going to get the funding, even with the additional money that's going to be distributed. That means 2/3 of the applicants that are already there are not going to get funding with the additional money that the city's getting. If you further do the math and look at the numbers, you will see that the city reviewed 52,927 applicants. That means that they didn't even review, this is what's unbelievable, they didn't even review 29,000 applicants. They didn't even look at them. Why? Because they knew that they're never going to get any money. It's just not available. So that means if you have about 3,000 applicants a week, that's over 2 months of applications that they haven't even looked at. Which means for the last 2 months, all those people that have been applying, which they forced you to do before you could file an eviction case, was just a total waste of time. Greg's been telling the city and been beating on their doors to let them know that this is what's happening. You gotta stop forcing us to apply for rental assistance when there's no money. The money is just not there. Okay. Finally, last Thursday, they said, hey, you know what? We don't have the money. We're going to stop taking applications. So that's where we're at with rental assistance. They stopped taking the applications. As I said, they should have stopped months ago. taking the rental applications, but they just stopped as of last Friday. So you no longer have to apply for rental assistance. Let me talk now about the diversion program and the history of that, and then I'll tie the two in together. Back in September of 2020, the city came out with a program that said that before you can file an eviction case, you have to go to diversion or mediation. I don't know why they use the word diversion, but it's really mediation. So this is back in September of 2020. They said you have to go to diversion first before you can file an eviction case. And that program is going to last through March the 31st of 2021. So on March the 31st, 2021, the law that was passed by City Council ended with regard to diversion. Around the middle of March, the city realized what was happening and that this was going to be a problem for them because they wanted the diversionary program to continue. At that point, City Council wasn't able to pass legislation quickly enough to get it to continue. So the strategy that they used instead was to get the courts to issue an order saying that the diversion program is going to continue. And as part of that, they said that before you can file for an eviction case, you also have to ask for rental assistance and wait 45 days. That's how all that came about in April of 2021. That's when the first marathon that we were running that we thought was going to end got extended back in April of 2021. The courts have since then continued to extend that order for diversion and to have to file for rental assistance. The court's order was based on the Supreme Court saying that local courts had the authority to issue emergency orders. That authority was coming to an end. The municipal court petitioned the Supreme Court to be able to get an extension to be able to extend those orders. The Supreme Court in November said, we're going to allow you to extend it till the end of December 31st, 2021, no more court orders with regard to extending the diversionary program. City Council realized that they were no longer going to be able to rely on the courts to extend the program, so they quickly introduced a bill and with just putting it together without notifying anybody and to continue the diversionary program. And that's the new bill that we're facing today that I'm going to explain how that all works. That bill went into effect as of January the 1st. So that's when they again moved the goalposts further back, extending it from January the 1st. This new bill has a 1-year period. It goes from January 1st till December the 31st of 2021. That's what the bill says. It would be great if we, not great, because who wants this to last for a year, but it would be nice if we knew, okay, at the end of this year, we know, okay, it's finally, this is it, it's going to end. But unfortunately, we don't, because the guess is that before the end of the year, they're going to extend it again. And God only knows for how long. So that's what we're faced with. So I now want to explain to you what the new diversionary program is. I just wanted to give you a little bit of a background so you understood how we got to where we're at today. The new diversion program that starts as of January the 1st of this year says that if there is rental assistance, then you first have to apply for rental assistance and wait 45 days before you can file an eviction case. Okay, as we said, that rental assistance has ended, so that no longer applies. What does apply, however, is that before you can file an eviction case, you first have to file for diversion or mediation. and you have to wait 30 days before you can file an eviction case. Under this new city ordinance, they extended the diversion to not only include non-payment of rent cases, it now includes every single case, includes termination of term cases, and it includes breaches of the lease cases. The only cases that it does not include is cases where I'll give you the exact language, shall not apply if eviction is necessary to cease or prevent an imminent threat of harm by the person being evicted. Very high burden to meet. So I get a lot of people say, oh, can I just go ahead and file for eviction right away? I don't have to go to diversion because there's some type of a threat of an imminent harm. On most cases, my recommendation is going to be file for the diversion. It's 30 days, because if you don't and you try to go to court, court cases, we don't know when they're going to be scheduled and how far out it's going to be. Now that they're getting a lot of cases, those dates are going to get further and further out. You don't want to be in a situation where you end up in court, judge says, sorry, that's not an imminent harm, and you now have to start over from square one. So unless it's a really egregious case, my recommendation is file for the diversion. In order to file for diversion, you need certain information. The most important thing, or the most difficult thing to get for landlords is the cell phone number and email address of the tenant. If you do not have that, you cannot file for diversion. When you go through the form online, it's going to ask you for that. And if you don't fill that in, it won't let you get to the next box. If the tenant doesn't have an email address and you put NA or not applicable or anything else that you write in there and don't put at the end of that .com, it won't let you get it to the next screen. You're going to be stopped. So when not sure how we're going to get around that, have a conference call with the city to try and figure out how we're going to deal with that. So if you want to put in there notapplicable.com, if you want to put in some other email address, because the person doesn't have one, you need one to put it in there. Is that okay? Not really sure. I can't give you legal advice to say, go ahead and do that. But if it was me, that's what I would be doing. I'd put in some email address because they just don't have one. What are you supposed to do? If the law says that you have to make a good faith effort to cooperate and apply for the mediation or diversion. What does a good faith attempt mean? So we've been given some examples of it. It does include, according to the city, that you give them the information so they can contact the tenant. We don't know what the courts are going to say a good faith attempt is. That's the city saying that this is what a good faith attempt is, but ultimately it's going to be up to a judge to decide whether you made a good faith attempt. So if the person doesn't have an email address, okay, you made a good faith attempt, they just don't have one. If they have one, but you haven't gotten it, that's where you're going to run into a potential problem. In theory, you should only have to provide one or the other, meaning a cell phone number or email address. If you don't provide either, you're going to run into a problem. So figure out some way to get one or the other. If the person doesn't have either, I'm not really sure what you're going to have to do here. But in order to file for the eviction case, you're going to have to fill out the form. So again, you want to just put some number in there, phone number in there, whatever, you know, to get to the next block so that you can at least get eventually to a court hearing where you can at least argue that you made a good faith attempt. Hopefully that makes sense to everybody, and we can take questions on that at the end. I highly recommend you trying to put in a sample case so you can see exactly the information that you're going to need to be able to apply for diversion, because unless you do that, you will not be able to file a landlord-tenant case. You absolutely have to file for diversion first. Along with filing for diversion, you also have to give the tenant a notification of rights. The notification of rights form was provided by the city. It's also on Hapco's website. So you can either get it from Hapco's website or you can get it through the city. It's called a notification of rights. You have to send that notification out to the tenant first, because you're going to have to upload a copy of that notification along with proof of mailing to the website. Not really sure what proof of mailing means. Doesn't say certified mail, it says proof of mailing. So query whether or not you have to do it by registered mail. If you send it by mail and you take a photocopy or copy the envelope with the stamp showing that you mailed it, is that good enough? Is that proof? Not sure. I filed over 100 cases. I haven't gotten one back yet to let me know whether or not they're approved or not approved. So I should know within the next day or so whether or not that's good enough. We'll have a better idea. If you're not sure, you can certainly send it by certified mail. Can't hurt. You know, when you got hundreds of them, it starts to get expensive. I think registered mail is good enough because it just says proof of mailing. It doesn't say certified mail. A lot of times in the law, when it requires certified mail, specifically says certified mail, proof of mailing, generally registered mail is okay. Or you got to provide some type of proof to the court. You can also hand deliver it. Okay, I don't know how you're going to upload the proof of the hand delivery. You know, you put it under the person's door, take a picture, upload it to the website. Will that be sufficient for them to get you to get your diversionary application approved? Again, we're going to have to wait and see how that all shakes out. But the safest way, if you want to make sure that it's going to get approved, is send it by certified mail. Costs you a couple extra dollars, but you know that that will get approved. Upload a copy of the green card, and you should be good, along with a copy of the letter. In addition to that, you're going to have to upload a copy of the tenant's ledger. So the two things that have to get uploaded are the tenant's ledger and the proof of mailing of the notification of rights. The ledger has to go back to the time that the tenant last had a zero balance or 2 years, if they didn't have a zero balance within the last 2 years. In addition, the city is requesting that you also upload a copy of a judgment by agreement that you're willing to enter into with the tenant. Personally, I have a problem with that. Negotiations 101 is you don't make an offer first and you don't negotiate against yourself. As far as I'm concerned, your judgment by agreement is pay what you owe. You owe all this money, pay it. If the tenant wants to come back to you and propose something, that's great. They should be the ones proposing something. We shouldn't be going in there and say, oh, we're willing to accept. That's ridiculous. Okay, but be that as may, if you want to go ahead and do that, you can submit that. The city is asking that you do that. Actually, it's the tenant organizations are asking that you do that. It would be helpful for the mediator to have that information if you are willing to accept less. So that's up to you. My personal opinion is I don't want to negotiate against myself. So I want to hear what the tenant has to say. I want to know what they're able to do. It's not a question I would accept less and say, oh, that's great. Okay, I'll pay you less. I'll pay it over X amount of months. It's wonderful. If you once you upload all that information, then hopefully your diversionary application will get approved. Then what happens is, as part of the diversionary notice, the tenant is given a phone number, a hotline that they're supposed to call. My understanding is that if the tenant doesn't call that hotline and or they are unable to get a hold of the tenant, you will not get a hearing. diversion. So you'll just have to wait the 30 days. On the 31st day, you can file the complaint. I'm guessing that there's no way that they're going to have enough manpower to be able to call all these tenants. For kicks, I called that hotline just to see what would happen when I called the hotline that they had for the tenants. Figured, okay, let me call and see what actually goes on when you call the hotline. So first of all, that hotline is also for the mortgage hotline. It's the same phone number. It's also for the rental assistance hotline for tenants. And now it also is supposed to handle diversion hearing calls. I called, I waited on hold. It said, you can leave a message or you can wait. So I clicked, I'm going to wait. I'm waiting and waiting and waiting. It gets on. It says, you can leave a message or you can continue to hold. I said, I'll hold. I want to talk to somebody. When I first called, they said, there's 2 people ahead of you. 17 minutes later, they got to, I won't say a person because I guess it's a recording, said, if you would like to leave a message, please leave a message at the beep. And so I said no. So I tried to hit 0 to try and get to somebody, representative, agent, help me. Okay, nothing. Kept saying, if you would like to leave a message at the beep. I refused to leave a message. It hung up on me. So I waited 17 minutes and didn't get to a person. So were they talking to other people, those other 2 people during that 17 minutes? Unknown. Assuming there was 2 other people that they were talking to, you're talking about 8.5 minutes or more, depending on when I got in and that first person was talking to them. It's at least 8.5 minutes per person. Do the math and figure out how many people they're going to need to man that hotline. It ain't happening. So I don't know what they're thinking, but that's the situation that we're faced with. And unless that tenant calls that hotline and doesn't get frustrated in talking to that hotline, you're not going to get a mediation hearing date. So again, that's one of the things I'm going to be talking to the city about to see if we can figure out what's actually happening with this program. The reality is, in my opinion, it's just a 30-day delay is what's going to end up happening, because how many of these cases are they actually going to be able to talk to these people, get them to a housing counselor, and then set up a hearing date for mediation within 30 days. On that 31st day, no matter what, you can file your eviction complaint. The law says that even if you filed the eviction complaint, if you haven't had your hearing yet on the eviction complaint and they set up a mediation hearing, you will have to attend that mediation hearing. Okay, so just the fact that you filed a complaint doesn't absolve you of the obligation to continue to follow through with diversion. At your court hearing, and again, we don't know how these are going to work because this is all new and we haven't had any yet because the 30 days hasn't transpired since diversion has gone into effect. Presumably the court's going to look at this and ask you for proof that you did all the things that you were required to do. You shouldn't have to provide the proof because you shouldn't be able to, you can't get to that stage unless you've done all the other things. But I'm guessing the court's going to want you to provide the proof of all those things. So make sure that when you go to that hearing, you have proof of all those documents, meaning the ledger that you uploaded, the diversionary notice, and proof that it was served. Okay, next I want to talk about Ritz and Aliases. Basically, the court said, and this is the court, this wasn't legislature, this was the court, said that you can't file an alias writ if there is a completed application for rental assistance that's outstanding. We never really got a clear definition on what does completed mean. It means a lot of different things to a lot of different people. At this point in time, my opinion is based on the fact that they have no more money and they're going to be running out in the next couple of weeks, and very few additional people are going to get rental assistance. unless the application says approved with funding. As far as I'm concerned, it's not a completed application, and that you should be able to proceed with the written alias. Again, we don't know how that's going to shake out. But at this point in time, I'm hoping that that's the way the court's going to rule. Obviously, you can't file for any more rental assistance. Rental assistance is up. There's a finite number that's there. Worst case scenario to me would be if you have an approved application, they can make an argument that there's still a slim chance that that tenant could get the funding. So possibly approved without funding yet might stop you from being able to file a written alias, but we'll see how that shakes out. If it says approved with funding, you absolutely are not going to be able to file. If you've gotten rental assistance, the law says that you can't file for 90 days after the period of time within which you've gotten the rental assistance. The law actually says that you can't file within 90 days from the date of last payment. That's very confusing, because if you got the last payment if you got the payment in January, but it applies to March, April, and May of last year, you should be able to file right away. You shouldn't have to wait 90 days. It's my opinion that the law is going to be interpreted, and again, we have to wait to see what the courts say, but I believe that they're going to say it's 90 days from the end of the last period that the money was applied to. So in that scenario, if it was applied to March, April, May, that 90 days after May 31st, you should be able to file, even though you've gotten the money after that period of time. If you've gotten the money, and this situation sort of happened in reverse, where if you got the money, let's say in November, December, and January the 1st of this year, it's not 90 days from January the 1st when you got the money. It would be 90 days from January the 31st, which is what the period is that the money applied to. I know that's all very confusing, but that's what's happening with regard to the Ritz and the Aliases. And I think that's everything. I'm ready to take any questions that you may have. I see you got 13 of them in the chat.
Paul, I have a question before
Yes.
that. You mentioned about the proof of mailing. So what Hapco is asking all our members was to do three-way, which is if you have the phone number, text them the notice. If you can do the certified mail, do that. And if you have the email address, send email as well, so they have enough proof to show them. So I think that is a good option after we talk to Barrett's as well as others. And most of the members have, COVID, and they are tackling with a lot of things. They cannot go out. So this is what they are doing for all of the people who are in the participants list. If you don't know,
and if you're going through Hapco in the Barrett's office, they will do all that for you. You just send all the information over. The key is make sure you send them copy of the ledger, copy of and just give them the tenant's cell phone number and the tenant's email address. They're going to need those three things. They can take care of everything else.
Okay, so let's go to the questions. I think the first question is from Troy Batter. If I'm not even trying to collect any money and I simply don't want to renew a lease and the person doesn't leave in 30 days, do I have to go through the diversion process? There is no money to mediate.
Yeah, it's an easy question. Yes.
Yeah. Next question is from Light. Will this meeting be recorded?
Just so you know, before you didn't, now you do. They just want, bottom line is, the goal of tenant organization is to, number one, stop evictions if they can. If they can't stop them, to delay them.
Yeah. The second question is, will this meeting be recorded and available for future review? Yes, it will be recorded, and it will be available today evening or by tomorrow in the website. And can I being evicted on a tenant that I just gave her notice to quit on 15-day to vacate?
No, you have to file for diversion.
I was granted possession on December 13th for an eviction I filed. Can I still sue for damage and unpaid rent?
Possession on December 13th for eviction, still sue for damages and unpaid. Yes, absolutely.
I filed an eviction in November.
I think you skipped the question.
No.
Is the eviction diversion process faster if I'm not bothering to collect? Okay, no.
Okay, from Thomas, I was granted possession, sorry. I filed an eviction in November. Do I have to go through the program? From Portia.
No.
From Thomas, when you file for diversion and click submit, does that mean the tenant is eligible?
Let me just go back a second so we're all clear. If you've already filed an eviction case, then this law doesn't apply to you. This law applies to cases where you have not filed for the eviction yet. And it basically says prior to being able to file for eviction, you have to follow the procedures that I outlined. If you've already filed, it doesn't apply.
Okay. And from Jim Bennett, you can use a certificate of mailing.
Yes.
The post office has a type of proof of mailing form you can use. Go to the post office, have them postmark it, and get the proof of mailing for it. It's a small green and white piece of paper. So that's an information from Anita.
Yeah, that's basically what Jim was referring to.
Yeah. So just like assistant's app, 2x3 will go nowhere. Maybe the answer is more courtrooms, longer hours, and more working judges.
Yeah, well, I don't know if you saw that latest Inquirer article, and the press has been snooping around the courts for days now. Their latest argument is that the courts are so overcrowded with tenants that it's creating a huge COVID problem, and the courts are very cognizant of what's happening with the press, and something's going to happen with regard to that. So you're absolutely right, Jim, and if that could happen, that'd be wonderful, but don't hold your breath.
And from Thomas, does the Hapco eviction program include the diversion process?
Yeah, absolutely.
Yep, I just wanted to add for now, our Hapco eviction page is on construction mode to change all this eviction process updates. So the website will open today evening or by tomorrow for all the members to start doing that. We'll be providing all the information on the website as well.
Yeah, with regard to Montgomery County, that comment, yes, the counties are much better. Not all of them, but most of them are for sure.
Did you have to apply for diversion? Okay, so
yes,
that's a conversation, I think.
Okay.
If you have already filed a case and it was sent to Hapco lawyers, will that case go through the normal court process, or will it be automatically sent to diversion program?
Well, the process for an eviction now is you have to go to diversion first. So if it hasn't been filed on yet and it's a new case, then absolutely it'll go diversion first. So the first thing that will happen is the notification of rights will be sent out, and then simultaneously there will be an application for diversion. And for those of you that don't have the notice to quit waived in your lease agreement, you can send out a notice to quit at the same time. So you can send the notice to quit, notification of rights to the tenant, and then file for diversion all at once. Wait the 30 days, 31st day, file for eviction.
Okay. So again, I think there is a conversation, so we'll skip that. Hi, what about if your tenant was denied for the rental assistance program? What about if your tenant has threatened you with bodily harm?
So if they were denied, doesn't matter. If you haven't filed for diversion, then you're going to have to file for diversion. If you file for rental assistance through Hapco, they filed for diversion at the same time for you, that was already taken care of, so you won't have to do it again. If the diversion, if you either filed for court or you filed for diversion previously, you do not have to do that again. If you haven't filed for diversion and haven't filed for court yet, then you do have to file for diversion. And as I mentioned before, if you believe that it's an imminent threat of harm that is being caused by the tenant, then you do not have to file for diversion, but it's got to be a very egregious situation. And again, my suggestion is going to be, unless it's really, really bad, file for the diversion and wait the 30 days.
From Andrew, do you have to wait 90 days after receiving rental assistance if you are filing for possession?
Yes.
Where do I file for damages and unpaid rent? Like Thomas.
So I assume that question is one where the tenant has already vacated the property, so you can file a separate action in landlord-tenant court for the money that's owed for the damages and unpaid rent. It's similar to a small claims case.
For Rachel, if a lease is month to month and you want to send a 30-day notice to end lease, do you need to go through diversion, or can you just send the required 30-day written notice to end lease and the tenant must leave the property by then?
So you can send the notice for them, notice that the lease has ended and that they have to vacate. But the problem comes in where the tenant doesn't vacate. So if they don't vacate after the 30 days is up and the lease is ended, then before you're going to be able to go in the court, you will have to file for diversion. So it's up to you to figure out, if you don't think that they're going to leave, then file for diversion right away, so you get those 30 days running, so that when the term of the lease is over, you'll be able to go ahead and file the eviction case. So it's one where you got to sort of weigh whether or not it's worth the money to go ahead and file for the eviction case ahead of time and or do the diversion program. My suggestion is, you contact the tenant and find out, are you leaving? Ask them. Tell you that they're refusing to leave, then you got a problem. Then go ahead and I would file for diversion right away. If they say, yeah, I'm going to leave, and you see moving trucks and they're packing, then you're good to go.
Yeah, but we also used to ask all of our landlords, you know your tenant best, so do you think you can trust that or not? So it's up to you. Next one is from Paula. The eviction process started pre-COVID-19. How do you get things back in motion since the diversion process does not apply?
If you started through Hapco, the eviction process, then they sent the rental assistance application and also already filed for diversion on your behalf. So 30 days from that point, you will be able to file for an eviction.
From what about if Hapco has already started the eviction process? Do we just continue to wait? Does this change anything, and how? No.
I think I just answered that.
Yeah. So what's a diversion through Hapco? We will be putting that information in our website very soon, so you can read that.
It's just real simple though. It's give the information, as I mentioned before. You just have to have the tenant ledger and the tenant's cell phone number and email address, and then it's the standard stuff that you always send for an eviction case. Send that over and Hapco will take care of the rest.
Mm-hmm. If the 45-day waiting period from the date of applying for rental assistance expires today, can I still file a new case now based on those 45 days from their application, or do I need to start over with 30 days for diversion?
Yeah, so that's a great question. If you haven't filed for diversion and haven't filed in court yet, then the question is, hey, I filed, and I get it. The question is, I followed the law. I did everything you told me to do. I waited the 45 days. I should now be able to file for eviction. It goes further because the law previously said that when you file for diversion, they meaning the city, was supposed to automatically enroll you in diversion. The problem is that they didn't automatically enroll you in diversion. And if you read the strict letter of the new law, it says before you can file an eviction complaint, you must first file with diversion. So my reading of that law and what I think the judges are going to tell you is that because you haven't filed for diversion, you need to do that before you can file a case. So you can take a chance and try and file your complaint. My guess is they'll turn it down, but assuming they accept it, the problem you're going to have when you go to court, that's a defense that the tenant can raise. The tenant's going to absolutely raise that defense. And if they don't, the law says, and this is unbelievable, but the law says that the court can, what they call sua sponte, which means the court can, on its own motion, raise it as a defense for the tenant. So the courts are going to be looking at whether or not you file for diversion, even if the tenant doesn't bring that up as an issue. So my suggestion to you is, as much as it stinks and you shouldn't have to do it, I would hate for you to file a case and find out when you get to court months from now that your case is going to get thrown out because you didn't file for diversion. So for the 30 days, and I know it's a lot, having to wait another 30 days after having waited all this other time, but I would file for the diversion, wait an additional 30 days.
Yeah. And I think it's similar like last year, early 2021, we had the same rules and we took all the cases through diversion at that time. So it's kind of similar. It's better to go through diversion first, so to make it risk-free. So the next question is, if the tenant is involved in destructive criminal activity or worse, how can you get relief?
So first of all, if that's the case, then you can file without going through diversion first. You're not going to get a hearing for months. Separately, there are actions that you can file to get into court immediately. You can file an emergency action, and there's other things in common pleas court, and there's other ways that you can file actions to get possession quicker. It's very expensive. Contact your attorney. That's a whole seminar on just that.
Yeah.
But the short answer to your question is there are methods that you can use to get relief right away if it's that bad.
Does Philadelphia have the legal authority to mandate a 30-day wait and a non-legally binding mediation process as a requirement before filing a LT complaint?
I have been emailing back and forth with Jim on this exact issue. Unknown. I don't believe that you would win, actually, if you filed a case against the city. Could you possibly win? Sure. There's arguments that could be made. I think at the end of the day, you're going to lose. And the reality is it's a temporary law that's going to end at the end of this year. That is a long time to the end of this year. Will they probably extend it? Yes. Is it worth trying to fight? I don't know. It's very expensive, and you got to make sure that everyone has the appetite for putting up the money to go through a long legal battle. And one that you can't guarantee is going to win.
Yeah. And Troy, are there two notices that I have to send, a notice to quit and a notice of diversion rights, or is it just one notice? And I wanted to add one more thing. There were people calling us and asking, do we need to send notice to quit and notice to terminate the lease? So I think, Paul, if you can answer that question, that would be great.
So the one notice, the notice of rights, absolutely has to be sent. The notice to quit has to be sent if it's not waived in your lease agreement. If it's waived in the lease agreement, then technically it does not have to be sent. Can't hurt to send it at this point in time because you're going to have to wait the 30 days anyway. So as just a precaution, you might as well just send the notice to quit as well as the notification of rights. We didn't want to send it before because it would delay things. You'd have to wait to be able to file. Now, since you're waiting the 30 days anyway, it can't hurt to send the notice to quit. As far as a termination of the term, it depends on what your lease agreement says. But if the lease agreement requires you to give them notice that you're terminating the term, then absolutely you have to send that notice of termination of term. If the lease agreement just automatically ends and doesn't have an automatic renewal clause, then in theory, you don't have to send it, but I would send that as well. Can't hurt to send it. Again, you have to wait 30 days anyway. So you might as well send it so that when you go to court, there's no reason for your case to be dismissed.
So is it possible for them to send us one notice for notice to quit and terminate?
Yes.
Yeah, okay. From Lisa, so if you and your tenant filed for rental assistance and the rental assistance needed more information, was the tenant entered into the diversion program and we can just file to the eviction, for the eviction?
So the computer systems don't talk to each other. So if you filed for rental assistance, that does not count as filing for diversion. If you previously filed for diversion and now want to file under the new diversion program, that doesn't count as well. You have to refile under the new diversion program. The new diversion has different requirements than the old diversion has, and the form is completely different. So you would have to file for new diversion and start all over again. I can tell you that when you go through in filling out the form, once you hit send, if you made a mistake, nothing you can do. You can't pull it back. You can't add to the form. There's no way to get to the form that you already sent in. So what I do is if I made a mistake, I just do another one. Just apply again, assuming that the first one's going to get not approved. And I'll send another one and okay, hopefully that one will get approved if you know the first one was wrong, instead of waiting for them to get back to you to tell you whether it was approved or not, because God only knows how long that's going to take. If they do, when they do get back to you, I can tell you that they give you a link to be able to fix whatever was wrong, which is good because I thought they were going to make you reapply starting from scratch. They don't. They give you a link so that you can just upload the new documents, which is good. It's kind of annoying to know that there's actually a link and a way to get in the back door to be able to add documents, but they don't let you do that until you've been denied. So if you know you made a mistake, you can't go back in and fix it. You got to wait till they tell you made the mistake, which is why I'm saying to you, I would just go ahead and reapply.
Okay. From Andrew, has the city made clear what the mediation process is going to be? Would it be similar to the arbitration case?
It's going to be similar to the previous mediations, assuming you're going to be able to even get a mediation hearing. The difference is in the past, what this city was doing is they were just pushing everybody to mediation, to rental assistance. Mm-hmm. There's no more rental assistance. So what's mediation going to do? They're going to try and force you to reach some type of long-term payment agreement. Whether you do or not, that's going to be up to you.
Okay.
I mean, that's all they can do. Tenant owes the money.
Yes.
The tenant's going to say, okay, here's how I can pay you. Do you want to wait for your money? It's going to be a decision that you have to decide whether or not you want to do that. And then the problem is that it has no teeth, which is what I've been arguing all along, is that if the tenant doesn't follow that agreement, where are you? You're nowhere. You're starting at square one. You still have to file an eviction case. So what you may want to do is say, okay, here's the agreement. If you go ahead and pay this, I will withdraw my complaint, but I'm filing the complaint because I want to get that started and I want to get a hearing date. So I'm going to file in court, but I'm telling you, if you do this, this, and this, then I'll go ahead and withdraw that case, but at least you got the case started. It's an option that you will have.
From Camilo, when I submitted my eviction to Hapco, the tenant had applied for rental assistance and it's been under review for months. I haven't been given a court date yet. My question is, will we have to file for diversion as well?
So because you filed through Hapco, they probably already filed for diversion. Just make sure that they have. And if they have, and the 30 days has gone by, you can file the eviction complaint right away. If not, then you got to file for diversion, wait the 30 days and then file.
Mhm. Paul,
And by the way, under review, you're not getting any money. If it hasn't been approved by now, you're not getting the money.
Mhm.
Half the cases that they've looked at are under review. Only half of the ones that they've looked at. And as I mentioned to you, there were thousands that they haven't even looked at. But of the ones that they looked at, they've approved about half of those. And if it hasn't been approved as of this time, the likelihood that it's going to get approved is slim to none.
From Paulette again, Hapco did not do the pre-COVID-19 eviction. Last rental assistance was received covering July 2021. How can the process go forward? Can Hapco help complete the eviction process?
You're going to have to file for diversion and then go to court.
Mhm. Rachel, if we file diversion, but we do not want to agree to certain mediation terms and we only want possession, but the tenant does want mediation, can we still proceed to eviction, or will the court frown upon landlords and not allow us to proceed to evict?
The court's going to frown on you, but legally you have the right to possession, so you can proceed to evict the tenant.
Yeah. From Stacy, I have already received rental assistance for a tenant last May. I am filing against.
Congratulations, you're one of the few.
Yes, I'm filing against them. Do I have to accept any additional funds from the tenant?
You don't have to accept it, but I would. It's going to be considered as if they paid it. So I tell everybody, always take the money.
Mm-hmm. Have lockouts begun? Yes. It's happening. Stephen, what's the difference between notice to quit and notice to terminate?
Just different terminology. It's the same thing.
Yeah, so that's all the questions. I think there is no more questions from the participants.
Awesome.
There's one new message. No, that's from Nadine. No.
All right, awesome. Thanks, everyone. Appreciate it. Sorry it was a little longer than I thought it was going to be. Hope it was helpful.
Yep. All right. Thank you so much for all the people who joined with us today. And this recording will be available by tomorrow in the website and YouTube. Make sure you sign into Hapco website before you try to get into the video. And thank you, Paul, for all the information and the webinar. And it's really helpful. And also, if you have further questions, you can call Hapco office. Again, you have to reach out to Barrett's and confirm each case as if it's like a little complicated, since there is a lot of questions all of us have. So there will be, back and forth communication. We have to confirm for each of the cases. But thank you so much for everyone for your time, and have a good day.